Hello everyone. Today we're embarking on a fascinating journey through the world of trademarks in India. This is Surya Nair along with Ms. Sakshi Sutar, and we are here today to demystify the complexities of the Trademarks Act 1999. The Trademarks Act of 1999 was passed by the Parliament of India. It is a comprehensive law that governs the registration and protection of trademarks in our country as per Section 1 of the Act. It is designed to provide better protection for trademarks for goods and services, and it extends to the whole of India. Navigating a successful process for trademark registration is required to build a unique brand identity and protect intellectual property rights. This journey, though intricate, is a pivotal stride for businesses aspiring to safeguard their distinctiveness in the marketplace. From the initial search for a unique trademark to the final issuance of the registration certificate, each step is plays a crucial role in securing exclusive rights and fortifying the brand's legal standing. Now, coming to the registration process of trademark, step 1, trademark classification. In the first step of the process for trademark registration, businesses are tasked with classifying their trademark into established categories under the NICE classification system. The NICE classification system comprises of 45 classes of goods and services, where classes 1 to 34 represent goods and the rest represent services. Trademarks are classified and registered into those classes for which they are intended to be used. In other words, trademark classification determines the scope of protection and use of a trademark, laying a precise foundation for the trademark registration process further. Step 2, that is the trademark search. Another prerequisite before venturing into the process for trademark registration is a comprehensive trademark search. This step involves analyzing local and international databases to identify any similar or identical marks that could pose a challenge to the proposed marks registration. A thorough trademark search not only minimizes the risk of objections during the examination but also aids businesses in making informed decisions about the uniqueness and viability of their chosen marks. It is to be noted that the trademark should follow the prerequisites under Section 9, that is the absolute grounds of refusal, which states that trademarks must not be distinctive or generic or descriptive in nature, and Section 11 that states the relative grounds for refusal, which raises objections relating to the similarity between proposed trademark and the existing ones. It should also follow Section 13, which prohibits the registration of names of chemical elements or international non-proprietary names, and also Section 14, which prohibits the use of names and representations of any living or dead persons or recently dead persons. Now, coming to step 3, which is the trademark application filing. After all the prerequisites which we already have gone through have been met, the next step in the trademark registration process would be the filing of the trademark application. As per Section 18 of the Trademarks Act, the application is to be submitted online to the relevant intellectual property office, requesting an examination and approval of the mark. Here, a single application is to be made which includes crucial details such as the applicant's information, a representation of the mark, and the specified class of goods or services for which it is to be intended to be used, as mentioned in the NICE classification system. And accuracy and completeness are paramount at this stage to ensure a smooth progression through the trademark registration process step by step. Over to Sakshi.
Imagine you're planting a seed for your brand. When it starts sprouting, it's like your trademark application being accepted. If there's no oppositions or hurdles, it's smooth sailing, and once it's accepted, the registrar gives your brand an official stamp marking it as registered. It's like your brand's birthday, and from that day forward, it is legally protected. The date of registration of a trademark is determined based on the acceptance of the application, completion of registration process, and issuance of the registration certificate by the registrar. This date holds significance in establishing the rights and protection associated with the trademark under the Trademarks Act. When you apply to register a trademark, like a logo or a brand name, there's a crucial moment called the date of registration. This date is determined based on whether your application was accepted without any problems, or if any objections were raised, they were resolved in your favor. The registration process. Upon meeting the above conditions, the registrar will proceed to register the trademark. The trademark, when registered, will be considered as the date of the initial application. This date of application, subject to certain provisions, is deemed to be the date of registration. Once the trademark is registered, the registrar will issue a certificate in the prescribed form to the applicant confirming the registration of the trademark. This certificate will be sealed with the seal of the Trademarks Registry. This is as per Section 23 of the Trademarks Act. With regards to the payment in context of trademarks involves fees or registration for renewal, restoration, and potential surcharges. Timely payment of these fees is essential to maintain the validity and to protect the trademark under the Trademarks Act. When applying for registration of a trademark, the applicant is required to pay the prescribed fee along with the application and is essential for processing the application for registration as per Section 18. After the initial registration, the trademark is valid for a period of 10 years. To renew the registration beyond this period, the registered proprietor must apply for renewal within the prescribed time, pay the renewal fee, and comply with any other requirements specified by the registrar. If the renewal deadline lapses and the trademark gets removed from the register, one can still bring it back by paying a fee for restoration along with any extra charges. Surcharges. In cases where a trademark is removed from the register for non-payment of fees, a surcharge may be applicable if the proprietor seeks restoration after the specific period. The payment of the surcharge along with the prescribed fee is necessary for the restoration of the trademark. With regards to the office which must be contacted for the registration process, in the context of the Trademarks Act, the respective office to contact for the registration process in India is a Trademarks Registry, as under Section 5. In India, if one wants to register a trademark after reaching the Trademarks Registry, which is the office that handles all things related to trademarks from processing applications to issuing certificates, they maintain a register containing your trademark or all other registered trademarks and handle tasks like renewal and restoration. If one needs help with trademark registration or have any questions about it, they can contact them at their main office or at their branch offices. They are there to guide them through the process and provide all necessary information with regards to registration of the trademark. This is as per Section 5 of the Trademarks Act. In summary, the Trademarks Registry is the primary office to contact for the registration process of trademarks in India. It plays a vital role in administering the registration system, maintaining the register of trademarks, and facilitating legal protection of trademarks under the Act. Therefore, Section 5 deals with the Trademarks Registry. Section 18 deals with the registration fee and Section 23 deals with the date of registration. Thank you.